Bismillahirrahmanirrahim. Alhamdulillahirabbil alamin wassalatu wassalamu ala asyrafil anbiya'i wal mursalin wa ala alihi wa sahbihi ajmain. Ladies and gentlemen, assalamualaikum warahmatullahi taala wabarakatuh, and a very good afternoon to all of you. Before proceeding, let me introduce a bit of myself. My name is Luqman Sharif Alias. I am a practicing lawyer and alumni of IIUM. Currently Deputy Chair of the Constitutional Law Committee at the Malaysian Bar and your moderator for today's session. Ladies and gentlemen, we are indeed fortunate today to have with us a distinguished constitutional expert, Professor Dr. Syam Rahayu, to discuss and enlighten us on a very hot and pertinent topic among the public, which is the Malaysian state of emergency, what the public should know. Prof. Syam Rahayu needs no introduction. Her views on constitutional issues have been sought by many, by who's who in our society, from Majlis Raja-Raja, Sultan, cabinet ministers, government bodies, and have been widely published in various mainstream media as well as social media. She now holds the prestigious chair of Kursi Institute Majlis Raja-Raja at UiTM. She is also an alumni of IIUM, my senior actually, and have been lecturing at IIUM prior to her appointment at UiTM. Welcome, Professor Syam.
Thank you.
For today's session, I intend to conduct it in a friendly and more conversationary approach. I will pose a series of questions which I believe the public are asking. If you have any questions, you can either state it in the chat session. I believe there's a chat session, which I will try to pick up as much as I can during the session, or you can ask the question yourself at the end of this session. There will be a Q&A session before we wrap up. Our session is scheduled for 60 minutes. Without further ado, let me start with the first basic question. Professor Syam, can you elaborate briefly on the Constitution? When can a declaration of emergency be invoked? How many times have we invoked it? And on what grounds were they invoked, including the current emergency?
Okay, Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Alhamdulillah Rabbil Alamin. Wassalatu wassalamu ala asyrafil anbiya'i wal mursalin wa ala alihi wa ashabihi ajma'in. Terima kasih, my brother Luqman Sharif Alias. Now, first of all, I would like to thank alumni unit at International Islamic University, Dr. Azam, and also all the technical committees for organizing this program. I'm honored, yet I'm humbled to be invited as a speaker for today's discussion. I take this opportunity to learn from all of you, and I don't think I know everything on the subject matter, and I believe you have a lot of people, including Brother Luqman yourself. You are very well known also as a constitutional lawyer. And we are proud of you, inshallah, that for your achievement leading the committee at the Bar Council. Yeah, thank you very much. First of all, probably I take this opportunity, the session, as for myself to learn and also to get feedback and comments or opinion from all our participants today. Yeah. There are a few things that I have to explain or to express myself regarding the question that have been posted by Brother Luqman just now. Of course, as we all know, I think many of us have read the Constitution, especially Article 150, Clause 1 of the Federal Constitution, where a proclamation of emergency can be made by the Yang di-Pertuan Agong upon his satisfaction. There's a grave emergency, darurat besar atau ancaman besar. Ya. Grave emergency on the ground of security of the Federation, keselamatan negara, economic life, kehidupan ekonomi, dan juga the public order of the country. So there are three main grounds why the proclamation or the emergency can be proclaimed by the Yang di-Pertuan Agong. But thus far, before Merdeka, since 1948, the first proclamation of emergency was made because of communist subversion. And after emergency, after the independence, the emergency was withdrawn in 1960. And the first emergency was proclaimed due to the Indonesian, what we call the confrontation with the Indonesia in 1964, 1963, and 1964 upon a formation of Federation of Malaysia. Yeah? And in 1966, the reason for the proclamation of emergency way back in 1964 was because of the confrontation. It's probably under the heading of security of the Federation. And in 1966, until 1966 or 67, in Sarawak, for a particular state of Sarawak. That is to say, the emergency proclamation can be made on specific location, or it can be made throughout the Federation. It can be made on many reasons, or only one reason. It can be made for many times. Let's say Batu Sapi now is under emergency. Emergency was proclaimed in Batu Sapi on the ground that was the reason to avoid election. And again, in January, proclamation of emergency was made throughout the Federation, and of course it will include Batu Sapi, Gerik, and also Bugaya. So meaning in these three places, there are two proclamation of emergency. One is specific for that particular state or particular constituency, and another is for the whole Federation. So proclamation of emergency was made in Sarawak State, in the state of Sarawak. And in 1969, as we all know, that the proclamation of emergency was made throughout the Federation on the ground of security of the Federation. In 1977, the proclamation of emergency was made for the state of Kelantan. Yeah? And some people mentioning about proclamation emergency on the ground of haze, because of the haze, that it was actually not under 150 of the Federal Constitution, but it was under the Majlis Keselamatan Negara National Security Council. It's not a progressive emergency, was meant under Article 150 of the Federal Constitution. Therefore, as we again we look at the current development last year, is about 3 proclamation of emergency was made for the purpose of avoiding proclamation of avoiding election, snap election, and probably the reason is different from the current that we are talking about, this 2021 proclamation of emergency. Yeah. So there are quite many times, almost 9 times, that the emergency have been proclaimed under Article 150 of the Federal Constitution, and there are various reasons. And the reasons for 2020, the Gerik, Bugaya, and also Batu Sapi was a different reasons than the current one, the current proclamation of emergency, and it was also different reason for the proclamation of emergency, which was made way back in 1960s. So we have seen that the main heading is about proclamation of emergency can be made on the ground of security of the Federation, the economic life of the Federation, and the national public order. Yeah, but these are the main grounds. And the public order, for instance, can be elaborated further, can be detailed further. That's what we have now, is probably because of pandemic. And the word pandemic has not been mentioned in anywhere except epidemic was mentioned in the decision of Sri Pengkalonikan, saying that the word public order may include epidemic. And in my interpretation, that the public order may include epidemic, it surely also include pandemic, because pandemic is more serious than epidemic situation. So if if we are clear that the proclamation of emergency will meet on the ground of ketentraman awam or public order, it can be on the ground of pandemic. Thank you, Luke. Whether I have answered your questions or anyone can add anything.
I think the question arising from all this is actually who decides whether there is an event of emergency, because as we know, I think on the 25th of October, while Yang di-Pertuan Agong had refused to declare an emergency advised by the government. But on the 12th of January, the Yang di-Pertuan Agong acted on the advice of the government in declaring the emergency. So is declaring an emergency, in declaring the emergency, must Yang di-Pertuan Agong decides, act on the advice of the cabinet, or does he have a discretion to decide whether the events, or he is satisfied that the events happen?
Okay, this is an interesting and a technical question, because people are talking about whether Yang di-Pertuan Agong is acting on advice, and because people making a generalization that everything that Agong make or action or inaction should be on the advice of the Jemaah Menteri. I will explain from both sides. Being academic, we will see both arguments, because there are weightage that can be given to all the arguments. But I will make my own preference, or what do I prefer from the arguments that are being posted by some lawyers. As you all know, there's a case being filed by our alumni also that the Agong shall act on the advice or not. But I'm not commenting on the case. It's just that as for academic discussion for our purpose today, I want to lay down before us the arguments, the legal argument on the issue. Actually, look, on that issue, I've written about 8 pages of writing to explain both sides, whether the Agong should act on the advice or whether the Agong shall act on his discretion. So I will explain one by one of the arguments that I've gathered for the purpose of answering the question. It may be lengthy, but I think we must be satisfied of ourselves as academic, and also lawyers also can take this one for their arguments before the courts, if any.
Maybe the summary of it.
Yeah, sure. I will briefly, or otherwise I'll be starting with I will be completing the time, finishing the time before this. But there are 2 arguments on this. Some people say that yes, the Agong must act on the advice. The argument is that, as what I said earlier, whether all action of the Agong must be on the advice of the Perdana Menteri. Therefore, similarly applicable when the Agong is going to proclaim emergency, it should be on the advice of the Perdana Menteri or Jemaah Menteri. Their reasons is because Article 100, because of Article 40, whenever Yang di-Pertuan Agong is exercising his powers or His Majesty's powers under the Constitution, it shall be on the advice of Jemaah Menteri. And amendment will be made to Article 40 to include clause number 1A of the Article 40, clause 1A, to say that whenever it's required that Yang di-Pertuan Agong to act on advice, then he shall act on the advice. So this argument, people would say that this is on the advice. The Yang di-Pertuan Agong is also being argued that Article 40, clause 2, which provides for some discretionary powers that can be exercised by the Yang di-Pertuan Agong. Discretionary means budi bicara, and budi bicara means he doesn't have to act on advice. His Majesty does not have to act on advice. There were 3+1 items where the Agong the Agong shall act on his discretion. One is appointment of Prime Minister. Second, withholding a request for dissolution and calling the Conference of Rulers for meeting, and in any other case mentioned in the Constitution. So people argue that the Agong shall act on advice because proclamation of emergency is not part of discretionary power under Article 40, clause 2, A, B, C, and +1. So they say that there's no proclamation of emergency that can be made by Yang di-Pertuan Agong unless there is advice by the Jemaah Menteri. But people will say that the Yang di-Pertuan Agong shall act on the advice, shall not act on the advice because of the decision in, for instance, the case of Stephen Kaloningkan. It was proclaimed that it was decided that the Yang di-Pertuan Agong is the sole judge to decide. He's the sole judge to decide that is the proclamation of emergency. However, the decision in Tay Cheng Po way back in 1979 says that it shall be on the advice. Yeah, but after the case of Tay Cheng Po, amendment was made to the constitution. So earlier than that, in 1981, the constitution was made. The amendment to the constitution was made to delete to include the Prime Minister's power to advise the Yang di-Pertuan Agong for the proclamation of emergency. Yeah, so the amendment has very explicitly stated that the Perdana Menteri shall advise the Agong to proclaim emergency. However, the amendment has been another amendment has been made on the same provision to delete the advice from the Perdana Menteri or the Prime Minister to have what we have now. That is, the Yang di-Pertuan Agong is satisfied that there's a grave emergency. So the current provision stating that the Yang di-Pertuan Agong is satisfied that there's grave emergency, and the word satisfied has been interpreted by many constitutional lawyers to say that is satisfaction of the Yang di-Pertuan Agong, therefore you don't need the advice. At the same time, in 1981 also, Article 150 of the Federal Constitution has been amended to include clause number 8 of the Federal Constitution. Clause number 8 of Article 150. Then clause number 8 is the main focus now when we talk about whether the Yang di-Pertuan Agong shall act on the advice or not. But the Article 150 clause 8 was saying is stating that the questions, there will be no questions when the Yang di-Pertuan Agong is satisfied. And another issue is the court is denied of its jurisdiction to entertain any cases involving the Yang di-Pertuan Agong satisfaction or the Yang di-Pertuan Agong decision to make any ordinance on the question of ordinance or law made during the proclamation of emergency. Now, if I look at briefly what have been discussed or what have been the discussion, the pros and against the opinion that the Yang di-Pertuan Agong act on the advice of the Perdana Menteri or Jemaah Menteri, I personally believe that is a prerogative of the Agong. I believe that is a discretionary powers of the Agong because it's the word satisfaction itself, and also the history of the provision itself. And the history, initially it says that the satisfaction of the Agong, it was amended to include advice of Perdana Menteri, and again it been re-amended and to say that it's only the satisfaction of the Yang di-Pertuan Agong, reading together with 150 clause number 8 of the Federal Constitution, 150 clause 8 of the Federal Constitution, stating that there shall be no questions. But lawyers, no questions on the satisfaction of the Yang di-Pertuan Agong. But lawyers may argue clause number 8 does not mention about whether acting on the advice or not, but it was mentioned about the satisfaction of the Yang di-Pertuan Agong. So another reason why I say that my inclination to say that it's a prerogative of the Yang di-Pertuan Agong is because the historical perspective, because the emergency, as time the proclamation of war also is under the jurisdiction of the king. So there's some legal, some historical background. As an academic, I would say that also relevant, although the court may have different opinion, but I would say lawyers may have different opinion because lawyers seldom argue on the grounds of history and probably look and share things on this. Yeah, but I would say that it's a discretionary powers on the Yang di-Pertuan Agong, and then we don't need the advice. But of course, as far as the practice, the kingship is concerned, or His Majesty is concerned, they will also discuss with the Jemaah Menteri, and of course, because the Jemaah Menteri could be representing the democracy in our country, and the practice of the king is that consultation or musyawarah is very important before the Agong can make any decision. Legally speaking, that is my argument. I would say that is a discretionary powers of the Agong, and it shall not need the advice of the Perdana Menteri or Jemaah Menteri on that issue. Thank you.
Thank you for enlightening us, because there's a further step to this actually. So what we're hearing is actually in order to declare whether there's an emergency, your Prof. Shanghayu, your view is that there is a discretion to be exercised by the Yang di-Pertuan Agong. However, there is also another view that says you have to act on the advice of the Agong. Now, the question is, Jemaah Menteri, sorry. So going forward is actually the consequential question that arises is actually, once an emergency has been declared, to whom does the government be accountable to? Must the Agong still act on the advice of the government? Can Yang di-Pertuan Agong refuses or rejects to assent to an ordinance, or whether that ordinance must actually obtain the assent of the Yang di-Pertuan Agong during the emergency itself? So that is one is actually in decline the emergency. What about during the emergency itself?
Okay. There can be few situations, there can be few situations where the proclamation of emergency is made. Let's say in 1969, the proclamation of emergency was made at a time when the parliament was not in session, or the parliament is dissolved. That's the right word. In 1969, the proclamation of emergency was made at the time when the parliament is dissolved. Currently, in 2021, the proclamation of emergency was made at the time when Parliament is still alive, but the Parliament is not in session. It's two different things, right? If the Parliament is not in session, there's a Parliament, but Parliament is not in session concurrently. Therefore, the Yang di-Pertuan Agong has a full power to make ordinance. Similarly, when the emergency was proclaimed at the time when the Parliament is dissolved, the power is also centered towards the Yang di-Pertuan Agong. The Parliament shall only have powers to make law during the proclamation of emergency if both Parliament during the session concurrently. So concurrently means they are sitting together at the same time. That have been defined by Article 150 Clause 8. Therefore, at the moment, where although the Parliament is alive, but the Parliament is not in session, so the centralization of powers is towards the Yang di-Pertuan Agong. So there are two things that I want to emphasize here. One is about the executive authority, and another is the legislative authority. So the legislative authority is very well pronounced, is very clearly pronounced in the Constitution itself, where it belongs to the Agong. So there's no one else can advise the Agong in making the law or ordinances during the proclamation of emergency if the Parliament, both houses of Parliament, are not in session. So at the moment, what we are doing now, what we are facing now is that the Agong is the absolute authority in making the law, and there's no one else. Can advise the Agong on that, unless there's an ordinance saying so and giving powers to people to be, let's say, in Jawatan Kuasa Bebas, the special independent committee that have been pronounced in the Ordinance Darurat Kuasa-Kuasa Perlu Essential Powers for the purpose of 2021 Darurat, emergency. So now, to whom does the executive? I think on matters of legislative authority is very clear, right? There's no one else, but it's the Agong himself. It doesn't bar the Agong. It doesn't forbid the Agong from consulting anyone, and also from establishing any committee to advise His Majesty in making decision or making the ordinances. And of course, we do know that Attorney General Chamber will work with the Yang di-Pertuan Agong in drafting and also gazette the proclamation of ordinances during the proclamation of emergency. Probably what is in the minds of the general public is about what is the functions of government and whether the government can exercise its executive authority. Yeah, unless and until there's ordinance to bar or to forbid the authority, the Jemaah Menteri from exercising its powers, then the Jemaah Menteri can continue to function. Whether the Jemaah Menteri shall act to advise the Agong or not, it depends on the circumstances. Let's say in making the law, no, but in the decision making of, let's say, making policy and all, it still has to go back to Article 39 of the Federal Constitution, whereby the executive authority is vested in the Yang di-Pertuan Agong. So to act on the advice or not, since we don't have case law, so far, and then is subject to academic interpretation, and probably lawyers also have their own interpretation. Everyone has the right to interpret. Since I'm given the floor to explain myself, then I would say that the Agong has the power. I go back to the general authority of the Yang di-Pertuan Agong. But I have no denial to the functions of democracy. I always say that democracy must also work during the darurat, during the emergency session. I mean, the state of emergency. Why I say that the democracy has to work, because the government is still there. And centralization of powers have been very strictly mentioned in the Constitution only on the making of the law. On the promulgation of ordinances is belong to the Agong. But as far as the executive is concerned, to my mind, is based on the interpretation. So I would like to interpret that the government can still give opinion, but it goes back to the final powers of the executive authority that is vested in the Yang di-Pertuan Agong. I'm using Article 39 of the Federal Constitution. I don't know how the courts will decide on this, because if we go to court, I don't know how the courts will decide on this. But my preference is that we go back to the very basic requirement that it's all belong, the executive authority, it belongs to the Yang di-Pertuan Agong. Look, but if the Agong wants to make a very strict law denying the power denying the rights of the executive authority, it can be done. It can be done by the Agong making the ordinance, because the ordinance is very strictly, very obviously under the jurisdiction, under the authority of the Yang di-Pertuan Agong. But we don't find such provisions yet in the ordinance atau kuasa-kuasa perlu ni kan. We don't find that provision denying the authority of the Jemaah Menteri to do the policies. Therefore, my opinion is that it goes to the Yang di-Pertuan Agong, but it does not deny the rights of the executive of the other Jemaah Menteri as the executive authority, unless and until there's a provision denying so. And that provision must be made in the form of ordinance. So although we have centralization of powers to the Yang di-Pertuan Agong, but we must make sure also the Agong also shall follow the law. I mean, there must be a law to regulate on the operation of the Jemaah Menteri. But it have been for the purpose of 2021 emergency, it have been repeatedly by the Titah Diraja that's being issued by Istana Negara. It's always to say that the current government will work as usual, and the Agong will only be advised by one committee, that is a special independent committee that will be formed in soonest. So I don't know whether I've answered the questions or not. Please continue to answer your questions too.
Yes, I think you have. I think there are many issues I think the public should know that is within the realm of still debate. I think the issue, there are many views, right? I think for today, I think we would like to hear from a constitution expert, right? So that we have an enlightened view on the subject matter itself. Because the public is always asking this, say for example currently, right? Now, does under the current ordinance, they have suspended the parliament, right? Now, can this be done? Doesn't the constitution, as we mentioned, actually envisage a sitting parliament? Because there are provisions in relation to it. So the question is, can a parliament be suspended? And has this been done before? Has it happened before in the previous emergencies?
Okay, let me answer from a wider perspective. when there's a proclamation of emergency is made, we assume that the law continues, or whatever the practice that being practiced before the proclamation of emergency, our ordinary law or our ordinary practice will continue, unless and until there's ordinance stopping it. Yeah. So as far as the suspension of parliament is concerned, does the Yang di-Pertuan Agong has the right to proclaim or to prorogue the parliament? Dalam bahasa kita panggil menggantung parlimen tu kan. Does the Yang di-Pertuan Agong has the power to prorogue the parliament? The answer is yes. Yes, the Agong can prorogue the parliament, legally speaking. People from democracy will say that what are the reasons why the parliament is prorogued, why we stop the parliament from having the session. But to answer as a legal educator, legal academic, yes, the Agong has the power to stop it, to suspend the parliament. And the Agong is not given the duty to justify it. Why? Yeah, but I think, in my opinion, why the suspension was made, and there's no such reason. There's no reason that are being explained to us why the parliament was suspended, and people were saying that there must be a mechanism to check and balance of what been done by the government during the state of emergency, right? These people say that who is doing the check and balance and during the proclamation of emergency? I would say that, yeah, the Agong will has the power. Then this has been mentioned in section 14 of the emergency ordinance, the special emergency ordinance, emergency essential powers ordinance 2021. Section 14 says that the parliament can be suspended. So that's it. Law says so. How do you want to check and balance? Then I would say that how do you want to carry out check and balance? Although the parliament is suspended, there are few jawatan kuasa, there are few committee under the parliament can be moved to continue to become check and balance mechanism. It can be done. And also, it can also be done through that such independent committee, as has been to enhance or to enlarge the powers of that independent committee, to also to see on the matter of the exercise, on the matter of the executive authority exercised by the government. Yeah. So as far as the provisions of the emergency essential powers ordinance 2021 is concerned, it has been very clearly and obviously mentioned. Therefore, the parliament can be suspended. So we cannot question the. As far as the constitution is concerned, Article 150 says that we cannot question any ordinance passed by the parliament or by the Agong during the proclamation of emergency. And also that ordinance, then also it denies, as I said earlier, it also denies the power of the courts, the jurisdiction of the court to entertain any cases involving the ordinance made during the proclamation of emergency. Thank you, Luke.
Okay, thank you. So I think we all must be clear. I think from the proclamation of emergency, one of the view is actually Agong has the discretion to decide whether to declare emergency or not. Once emergency has been declared, the power is centralized to the Yang di-Pertuan Agong. The Yang di-Pertuan Agong have a lot of powers, including the right to reject ordinance, amend the ordinance, set up the government, and he's saying as well, is actually he can also suspend the parliament. And these are actually stated in Article 150, as Professor Sham is saying, that it cannot be challenged. I think the reasons cannot be challenged by the courts themselves, right? But you know, public, they are always asking for things. I think we are going into again the question of why we need this darurat. Essentially, many are saying these are for political purposes, though it should not be questioned. To them, I think there are sufficient laws to handle the COVID pandemic, right? So in your view, the current ordinance that has been promulgated, is it dealing with the current pandemic? How is the pandemic dealt in the current ordinance? Again, back to suspension, do we need to suspend the parliament in order to overcome the pandemic? As stated, right? Okay.
These are, I think this is a very, very obviously questions that have been posted to me also in few other programs, and for I think not less than 10, I think I'm attending discussion at the same question. But sometimes I have to develop my arguments also from the legal perspective. Yes. Yeah, why do we need darurat? Is it for political purposes, or is it for the purpose of combating pandemic, or whether there's any what I call as constitutional convenience on the part of the government by proclamation of by seeking they are going to proclaim emergency. My answer is this: I don't have the data of how serious a pandemic is, but we as citizens will see that every day now keep on increasing, or is still under the is still with 4 digits and reach 4,000 cases a day. So I think that is very serious at the moment, to my mind. It's serious, and there's some grounds to justify this, as I explained earlier. Coincidentally, the government is a weak government. Coincidentally, atau kita kata secara tidak disangka-sangka ke, coincidentally, the government is a weak government, or the other way around. When the weak government, then we have pandemic, and COVID is said to be as to save the current government, then depends on the pandemic. But I think we have to balance between the two. To my mind, in my mind, to balance between the two. Yeah, we cannot clean the argument to say that there must be some political reasons to retain the powers for the current government to retain the powers. Therefore, the proclamation of emergency is made. But I do also believe that grounds to eliminate or to reduce the graph of pandemic is also one good reason for the declaration of emergency. Is there good reasons for the proclamation of emergency? Because of course it's interrelated. I mean, not less than 3 times, the Yang di-Pertuan Agong has issued Titah Diraja by issuing a media statement to ask the politician to stop politicking. I remember Syed Munawar, Syed Munawar was saying, dia kata macam kalau nak stop politician from politicking ni seperti you minta pemain bola berhenti main bola lah kan. Syed Munawar ni memang ada tak dia kat sini. So I appear in few program dengan RTM lah, dengan Syed Munawar kan. Jadi I'm not saying about politicking. You can still sit in your political party and wear your political attire, but not to do politicking on matters that involve life or death of people. Yeah. So now, when we look at I would say, look on that point, I would say that there are grounds to say that proclamation of emergency is justified to be made or to be proclaimed on the ground of spread of the pandemic. It's allowed by the law, and there's been a court's decision to say that it's part of the ketentraman awam, it's part of public order. Therefore, legally speaking, it's fine to have that pandemic. And factually, from the physical appearance, we have this pandemic have been spreading very seriously deep into our society. Therefore, this reason. But probably people will ask now, as you said, look, what is there in the ordinance to show that the steps taken by the government in order to combat or to order to fight this COVID-19. Yeah, only few things that is found in the Essential Powers Ordinance. I hope the government will come out with another ordinance to be specific on focusing what's the government plan of action in order to fight COVID-19. Yes, in this current ordinance, we do have like a provision on the provisions against the suit of legal proceedings are also involved, and the procedures or demand or use of resources, provisions on usage of the pemilikan, power to take temporary possession of land, building, or movable property. And these are probably some actions, the general action that can be taken by the government to lessen the bureaucracy, for the government to take temporary possession of such, and also the punishment for refusal to abide by the order of the government is very big, is quite huge. Yeah, so I think there are provisions in this emergency essential powers ordinance, but to my mind, it's still insufficient. So we still want to have, especially what we call the frontliners, what benefit they have. Then we must have another ordinance focus only on that. This one is kuasa-kuasa perlu saja, only the essential powers. During the 1969 riots or proclamation of emergency, there were almost hundreds of ordinances being promulgated in order to tackle issues like, say, because it's involved security last time, yeah, it's involved military move, for instance, yeah. So this is also also important for us to look into, and we hope the government will come out, especially the Ministry of Health will come out with a proposal for new ordinance to make sure that this for the purpose of combating COVID. Let's say we have vaccine later on. So what's the laws? Then we have a very basic provision on this regarding vaccine. Yeah. So I think there must be a specific ordinance focusing on the plan of action, how the government will tackle. So we as rakyat, we know what the government plan of action. And now this is too general. To me, the ordinance, essential powers, too general. I mean, probably I'm too demanding, but I think as a responsible citizens, we want to know what's the next plan. Yeah. And of course, we always say that, and to be fair to everyone and to be fair to the government also, that they must be given some measure to make them easier for them to exercise what they plan to do. And probably if we have, I continue to this, something that Luke mentioned about, still about suspension of parliament. Yeah, if the parliament comes to session, Parliament may delay certain action that need fast, very quick action, because of course you know that people go to the Parliament. There was a proposal made by the government, and also the action done by the government, and people will debate on that. They close their book, they go back home. So how do they contribute to the government? This is real. COVID-19 is real, right? So it's not something that you just debate in the Parliament. Can you easily make a decision with 220 people in the Parliament? It's not easy for the government to face on this. This is reality. As we talk about democracy, let's now democracy is very limited. Then we just now control the powers or check and balance or power from outside the Parliament, not using the Parliament. I would say that, yeah, the general, to answer question just now, the Emergency Essential Power Ordinance 2021 is a basic law for the government to, as a kick-off, as a tee-off, starting point, starting action starting to their action to further develop another ordinance to focus on how this pandemic will fight against this pandemic, to combat this pandemic. And suspension of parliament sometimes may have some benefit in order to avoid lengthy of bureaucracy, lengthy discussion on whatever parliament, whatever government must do, but the government also must come out with the plan of action. That is most important. And last but not least, that the first question that was asked, whether it's for pandemic or whether it's for political, I'm more inclined to say that it's for pandemic, because this pandemic is real. The number is increasing. Our health infrastructure is almost occupied, means almost 80%, and some hospitals are almost 100% being utilized, and it's real. And how do we actually, for instance, the government will coordinate with the private hospitals. Yeah, so this is also need some less bureaucracy. If the government, the private hospital also to take this what we call COVID patient, for instance. Yeah, I think that is all. I have another point, but I forgot, and I will share when I can recall it. Thank you.
I think public must know. I think it's quite clear from the ordinance, as you mentioned, Prof. Shah. There are provisions to handle the COVID pandemic. It is worded in a broad perspective, and in your view, it's insufficient. There should be more ordinance for this.
Yes.
But this begs a question, I think. If we read the ordinance, it says that the government may temporarily acquire, say, for example, assets, right, or services, right? Now, we can understand that these are not provided in other laws, right? Yeah. Therefore, we need this ordinance to allow the government to tackle the pandemic. Maybe, for example, they would require a place to house the victims or those suffering COVID, so in an urgent manner. So this provides a mechanism for them. But the wording in the ordinance is worded very generally. Can the government acquire, say, for example, a place, acquire services not for the purposes of COVID? Is the wording wide enough for the government to exercise these powers beyond tackling the COVID pandemic under the current ordinance? What is your view?
Yeah, thank you, Lord. This is what I actually forgot to mention. This is indeed very, very important for us to look at the proclamation itself. Yeah, the proclamation made by the AGO was gazetted on the 12th of January. Yeah, but it's effective on the 11th of January. Yeah, it's important to take. I mean, it's important to give a special attention to the reason why the pandemic was proclaimed. And in the first paragraph of the proclamation of emergency, which has been gazetted by the government, that whereas we are satisfied that there's a grave emergency exists, whereby the security, economic life, and public order in the Federation are threatened, arising from the epidemic of an infectious disease, namely coronavirus disease 2019. So the proclamation itself has been very clearly made for the purpose of combating the things that threatening us, that is COVID-19. So Luqman's question was whether or not the government can make law for the purpose of something else, not coronavirus. I think legal answer is very obvious. You cannot do something which is not for the purpose of it. To my mind, one of the things that we have to be alert of is that we must make sure that government make law only for the purpose of this COVID-19. Because that proclamation only for the purpose of eliminating or threat by this COVID-19. In my view, the government cannot make law outside the ambit of parameter or outside the parameter of combating COVID-19.
Okay. So what you're saying actually, we need to read the ordinance together with the proclamation.
Indeed, yes, yes.
Because the ordinance is worded widely, it can be interpreted many ways. However, it will be subject to the proclamation of the ordinance.
Yeah, yeah.
That is your view, okay?
Yeah.
Okay.
Look, and one thing that I've forgotten just now was about deployment of military.
Yeah.
Deployment of military. I've been saying, I've been questioning, I've been meeting a lot of higher personnel and the ATM, Angkatan Tentera Malaysia. What law that are you using? What law that are you using to allow deployment of our military is standing in a road? I mean, standing in the public and to, to enforce the law. There's no such law to allow them. Before, when we use MCO under Act 342. Akta Kawalan Penyakit Berjangkit, there was no such law that allowing our military to be in the public assisting the police. Yeah, but it's only legalized when the darurat happens, when the emergency happens. Yeah, if anything, so let's say now the military shall has the power similar to the police. They can do arrest, they can arrest people, they can take statement, things like they are like acting like a police officer. But before proclamation of emergency, that's to my mind, there's no legal basis for the military to come out. I mean, from their camp and assisting the police, as we all see that when the military was doing the operation together with the police, they was just holding their weaponry and they don't do arrest. But during the proclamation of emergency and giving such powers to the military, this allows also the military to assist. But people don't be scared of this military. But I was talking to, officers, the legal advisor to the military. That will allow the military to come out, but of course they must also be familiar with the police power. Yeah, because the military are not trained as police. Military is trained as military, and the power to arrest, a power to search, and all that. That is not military law. We are still applying the normal law. That is the Kanun Keseksaan, Criminal Procedure Law. So it's not the military law that we are applying or the martial law that we are applying. We are applying the current normal law. But the operational can be done by the military. So this one thing I don't want to scare the public. Look, it's not the military law. It's not the martial law that we are applying, but we are applying the normal ordinary law. And the military is exercising the powers as the police. Police tak boleh exercise military martial law, kan? Yeah. So that is now the officer change their uniform and they exercise, the military officers, they exercise the police powers together to complement the police.
Yeah, okay. I think for me, I think it will be much clearer if I think the ordinance expressly state what is the purpose of this, I think.
Yeah, we do have that. We do have. One other thing, additional powers of armed forces under Section 7 of the Ordinance, they kata whatever rights provided for under the CPC is still applicable. It's not the martial law.
Yeah, that is correct.
And also together with the Armed Forces Act 1972. Yeah. One other thing I want to share, Section 5 of the Ordinance, Section 5 of the Ordinance explain that even the government or the Yang di-Pertuan Agong, anyone authorized by the Agong to take possession of certain property or resources, there can still be compensation. It's not about like, it's not like other system that you have, the law or the rule of law is still maintained. It's still maintained that our right to property under Article 13 of the Federal Constitution is still maintained because the ordinance also provide for some compensation to be paid.
Yeah, I think that is clear. I think the provisions are meant to be used to tackle the COVID pandemic. And in your view, it should be read with the declaration or proclamation of emergency. I think some people still always say, for example, acquisition of property. It would be better if there is a wording to say that for purposes of tackling pandemic.
Pandemic,
Okay,
yeah.
but I want to move on. I think the issue, the next issue is in relation to political purposes actually. Some are seeing this as for political purposes because I think the current government, as you say, is quite weak. I think the majority is in doubt at the moment. Probably in your view, under the constitution, say for example, there is a house of 220 representatives. If the government has support of 110 or 109, right? Does it mean that the government has lost its majority? And if it has lost the majority, must the government tender its resignation, right? As you mentioned just now, the clause and the constitution will and the law will prevail, will continue unless there is a provision to the contrary, right? So can the parliament be dissolved during this emergency period? Okay.
Yes, the parliament can be dissolved during the proclamation of emergency. Whether there's a, okay, first thing first lah, yeah. People argue that when we go back to the discussion, act on advice or without advice, yeah. People mentioning that I read something going around in the WhatsApp group, some arguments on the government at the moment that the government advised the Agong to proclaim emergency, the government did not have the majority support or majority confidence of the House. Once the proclamation of emergency is made, as I said earlier, the law continues, the constitution also continues unless there is some specific regulations to some specific law to deny so. So if we want to say that the government has to tender resignation and later on request for dissolution, I think there must be a clear provision on that too. Must be a clear provision on that too. However, this is one argument to say that there must be provision. However, if we look at Article 150 Clause 6A of the Federal Constitution, Article 150 Clause 6A, they say that the Parliament can make law which is inconsistent with the Constitution except on the 6 matters. Yeah, 6 matters: the hukum syarak, the adat resam Melayu, the adat anak negeri Sabah Sarawak, bahasa, agama dan citizenship. Ini saja yang tidak boleh bercanggah dengan perlembagaan. Jadi that's why I said the technical is like this. Look, I assume that all laws continues as it is, unless there's an ordinance to say that that's not applicable. Therefore, there must be an ordinance to say so. There must be an ordinance to say so. If the Agong makes such ordinance, is that valid? Yes, it's valid. Because it doesn't involve the 6 matters under 6A, under 150 Clause 6A. Unless the Agong wants to change provisions on citizenship, for instance, that cannot be done. That cannot be done because it's inconsistent with the Constitution. So what I want to say is that in the ordinance, the current what we have, the essential ordinance, is too essential powers ordinance is too wide. It's too wide and there's no specific such as what we discussed. What's the issue that we discuss now? Loss of majority and all that. And there must be, to my mind, there must be ordinance to explain such huge questions that are being discussed by the public.
Thank you. I think we're running out of time. There's a number of follow-up questions, but I would like to, I think we extend for a short while more. I think I would like to take some questions from the chat room. I think one question is from Kamal Mustafa, who is suggesting that why not we amend the constitution that the proclamation emergency should be followed by automatic dissolvement of the cabinet and country's administration. Will be taken to be taken over by the special committee. Another question is actually in relation to a specific time limit for emergency.
Okay.
Has there been any precedence on this?
Okay. Interesting. Can we amend the constitution? Yes, we do. We can. Yes, we can amend the constitution, but not at the moment lah. Sebab kita dah terlepas masa ni. Okay, mungkin after this lah, kawan-kawan akademik has to do some exploration, to explore on this, ya. Masalah kita di Malaysia ni sebenarnya rakan kita, sahabat-sahabat sekalian, we are lacking of academic exercise on this kind of thing, you know. We are taking for granted that being in good situation, yeah. So I would say that it can be made, whatever it is, we can be made. You want to amend the constitution, but it's easier said than done. If you amend to the constitution, you must lobby for this. You must get, of course, 2/3 majority. And yeah, over by special committee formed by the AGON, yes, I do agree not to centralize the powers, but to have the special committee as what we have in 1969 with Magaran. And this can avoid emergency being used for political gains as to save the current government. I don't want to comment on this last sentence because I do believe also grounds to say that COVID-19 is also a reason. It's not only a mere for political gain. Yeah, that's my stand on this, but it's okay. I agree to this agreement. It's fine because I know the general public is still talking about this gaining political support or berselindung di sebalik COVID-19. Yeah. And the second question is Brother Muhammad Noor. Is there any specific time limit or time frame for emergency duration as proclaimed? No, the Constitution does not state that the proclamation of emergency for such periods of time. There's no deadlines actually, but we are. I think we have to. I think we are pleased to accept that that the government has given only until 1st of August. Yeah, when Yang di-Pertuan Agong refused to the proclamation of emergency on the 25th of October 2020, among the reasons, among the critics or complaint was that emergency must be within a time frame. And when the government asked for put a time frame, there's a question why there's a time frame. Yeah, but saya fikir it's good for the government to have this time frame. It's good for the government to have a specific period of time that they will work hard. They will be focused. They focus on COVID-19 and how to find actions. That the government actually has not much time. If we say that now it is February until July. Until July, they have about 6 months to plan for. The last time we have MCO since March until June, when the cases was only 300 or 400 the maximum. Now we have 4,000 the maximum. So I think that the time frame is reasonable, but it's difficult for the government actually for that time frame. It's not easy for the government. I think it's 1 year. Is this my estimation? I may be wrong, I may be right, but I think 1 year is comparing to the seriousness of pandemic. Then are there any precedent in other foreign jurisdiction where emergency subsists more than 12 months? I don't think so. But of course, in other countries, we have armed conflict. They do have. But for the purpose of COVID, there will be 3-4 months. Yeah, any impact to the citizens at large? I think in 1 month time and in 1 week time, do we have any impact? Do we see any impact on the citizens? I think there's no adverse effect on the citizens, right? There's no adverse effect on the citizens, but it's more to, let's say the government pronounce some plan, economic plan and all that. There's also some kind to do with action plan for the purpose of combating this COVID-19. So a friend of mine is also a constitutional law lecturer. He was telling the students that it's not right to put the time frame. But this is a legal question. No? Sometimes dia kata, since the constitution says that the parliament can, the emergency can only be revoked by the parliament, and therefore it's not legal to put time frame. I don't think that is a right opinion, because I think there's no such limitation that there's no such limitation whether to have a specific time or whether not to have specific time. by the Constitution. So the Constitution allows the unlimited period of time for states of emergency. The Constitution also may allow for a period of time, for a time frame for proclamation of emergency. And there's no country so far in the world that have proclamation of emergency 12 months, more than 12 months for this pandemic. Then I don't think this darurat atau proclamation of emergency has thus far adversely affecting on the citizens. Thank you.
Thank you. I think for the public, they need to know, I think this is in a way a limited emergency as regards to the time. And then it can be shortened whenever COVID has been handled, I think in the view of Agong. So in that sense, it's again an argument that it is to handle the COVID pandemic, and this is what is available. I think I'm in the injury time right now. I'm not so sure whether I have time to take question from maybe one of you. I don't know. Is it open? Do we still?
I thought Dr. Azam was saying that we can.
Yeah, until 4:30.
4:30. Until 4:30,
yeah. So we have participants from Zoom. Maybe you can open for the question and answer.
Okay. Okay. Is there any question if you would like to ask?
But it's not about question. It's not only question. Look, let's invite comments or let's invite opinion. I think that is what we do. Not only me to answer questions because I may not know the answer. Let's share views. Let's share views from participants.
Hi, can I ask one question?
Can you state your name?
Kamal. Okay, Kamal Mustafa.
Okay.
So since with this emergency that I think Agong can make any law, right? An ordinance, right? Even it is right against the Constitution, except for the 6th item, right?
Yeah.
So is it possible to create a law that actually against the Constitution, like such as the anti-hopping law for party right now? Is it possible to create such law right now so that we can bypass the constitutional restriction that means that make it impossible to create such law in normal situation?
Boleh kalau if the Agong thinks that anti-hopping law can be made, but how does it affect the purpose of what we call proclamation was made? Is there anything to do nothing to do with COVID-19?
So we are bound to the problem.
Yeah, but then I have to Cik Kamal, I have to clarify myself. Yeah, that is my interpretation. In order to make sure that the proclamation of emergency for the purpose of the law made during the proclamation of emergency for the purpose of that proclamation of emergency only. Let's say this is for COVID-19, and whether can we make law for the purpose of anti-hopping law. If we look at the proclamation emergency, it uses 3 items though: security of the federation, then also economic life, then what we call public order. And then below it mentions coronavirus. If that coronavirus also affect the security, in what manner that the Agong find that security is being affected? Let's say due to coronavirus, people are spreading fake vaccine, for instance. So that is involved, or dangerous vaccine, for instance. So that is involved security. We define the definition of security of the country. So that can be made. Due to coronavirus, for instance, people take the opportunity of sabotaging our economy. So they may also be for the purpose of coronavirus, but it's a wider perspective. But how do we relate this to coronavirus? My point of view is that whatever law that we want to create, it can be against the Constitution. But this is implied limitation. This is my interpretation. Implied limitation that it must to satisfy, it must be in kalau dalam criminal law dia kata acquaintance lah, it must be in connection to what is pronounced in the proclamation of emergency. If we can prove that anti-hopping law is relevant at this moment of time, we don't think about after, because after proclamation of emergency, the law shall be tabled before the parliament, and the law can be withdrawn, it can be revoked, yeah, or if not revoked within that 6 months after the proclamation of emergency ends or have been revoked, the law will be ineffective unless it's being passed again by the parliament, ya. Tapi pada saya lah, is it relevant or not relevant? Kalau kita jawab soalan bolehkah? Jawapan saya boleh kalau dia related dengan COVID-19. Perlukah? Itu satu soalan lain, ya. Perlukah kita buat undang-undang itu? That's another question. And to me, at the moment of time, kita tak perlu buat akta itu. Itu pandangan saya lah. Terima kasih Cik Amal.
The question, if an ordinance is done, that cannot be challenged, betul tak?
True.
It's just that after that, it's just that after that, some other, it can last after 6 months too. We do not know whether the parliament can accept.
Yeah.
Then we go back to the same question balik.
Betul. Maknanya kalau Agung buat pun, Agung tak perlu bagi sebab kenapa Agung nak buat. Sebab tu kita kata it's non-justiciable, ya, dalam bahasa undang-undang kita kata it's non-justiciable, it's not being is not to be what we call decided by the court. Even peruntukan tu memang jelas menafikan bidang kuasa terus. Macam awak tak boleh file pun kes tu kan loh. Maknanya tak boleh file langsung kalau menafikan bidang kuasa tu. Jadi kalau balik pada isu tu, maknanya yang di-Pertuan Agong buat, dia tak explain reason kenapa, baginda tak explain reason kenapa. Masih lagi kita tak boleh persoalkan. Sekarang ni orang bercakap tentang centralization of powers lah, tapi saya selalu menyatakan bahawa Agong ni dia buat keputusan bukan suka-suka je, macam tu lah. Dia mesti ada bincang dengan orang-orang lain atau apa expert kan. Dia bukan mudah-mudah je, sebab wibawa institusi beraja tu akan dipersoalkan. The integrity of the institution shall be questioned if later on when the situation comes to, when it's already calm, and that is why then later on also the proclamation, reasons for the proclamation and all that will be tabled before the parliament upon the parliament comes to session later on. So the Agong shall not, kata jangan play lah, jangan main-main lah, because that will affect the integrity of the institution. That will if the Agong is not orang kata make a due diligence on doing this, the institution tu pun boleh collapse tau. Kan, that scares us lah. Bagi saya yang menyokong institusi raja lah, terus terang saya cakap, kalau silap raja, silap langkah, institusi ni boleh roboh tau. Kan. So itulah, janganlah kita macam dalam kes ni saya selalu menasihati kita tak payahlah terlibat sangat dalam politik-politik ni bagi institusi raja lah.
Okay, clear. Okay. Enough, I think. Any other questions?
There's one more in the chat box, look.
Oh, ada ya.
Cik Halim Hussein di PMM.
Halim,
Ada satu ni, Cik Alim ni, tak kenal ni.
From Melaka ni.
Oh ya ke, nak kenal lah kita punya alumni ni kan.
Alumni. Can we change constituency area change due to...
Can we change the constitution area change due to effectively ke? Constituency ni untuk election ke? Ke apa?
Mungkin Cik Alim boleh...
Kalau constituency untuk election ni, tak payahlah buat. Nanti Agong terjebak dalam politik ni, bahayalah. Tu yang macam saya cakap tadi kan, Cik Lim. Macam kalau jawapan saya lah, kalau ikutkan undang-undang, apa nak buat tu boleh lah. Tapi pada saya dia akan menjadi mengelirukan rakyat, dia akan menyusahkan institusi raja tu sendirilah. Tak ada nak jawab panjang lah. Tak pandai.
Any other questions?
Any other questions? Berapa
Kalau tak
ramai
boleh,
kita ni?
ada one more. I think probably a bit legal sikit. Because this cannot be challenged. I think there was an amendment whereby all the questions pertaining to ordinance semua cannot be challenged in court, kan? So they actually ouster clause, kan orang kata, kan? So not allowing the court to decide, kan? Now, in view of the case of Indira Gandhi and the like, kan, do you think this is challengeable atau tidak?
Sorry?
In view of Indira Gandhi and the other federal court cases, whereby it states that a law ataupun any amendment to the constitution cannot oust the jurisdiction of the courts.
Okay. Can I ask?
Do you think?
Yeah.
Do you think this can be this provision can be challenged? The amendments can be challenged now?
But then we look at there's other laws which ousting the jurisdiction tau.
Yeah.
There's other laws that I think there's one split opinion lah kan dari segi keputusan Indira Gandhi tu by our learned Chief Justice. There's one split opinion lah. Because there are a lot more other laws that have been also decided by the courts that there can be that ouster clause to oust the jurisdiction of the courts. And because the argument is basically on the spirit of the constitution, the democracy, but whatever that Luqman was mentioned just now is an arbiter, right? It's an arbiter. I think it's an arbiter. Whether it's a ratio or arbiter. What do you think, Luq?
I think there are two school of thoughts, kan? Two cases. I think one line of cases says actually you cannot oust the power of the courts. But I think the recent case we saw in Maria Chin's case, I think the majority is saying that the constitution is the supreme law of the land. So we must accord the constitution, whatever stated in the constitution, a higher power, right? So because they were trying to negate the provision whereby the court cannot review the decision by an immigration director general, right, in relation to not allowing people to travel, right? So it is ousting the power of the courts to review the decision of the immigration DG, right? So in that case, apparently the majority is saying that we must respect the constitution. If the constitution amendment is actually, if the constitution says that the court that should not have the power to look into such matters, I think we should respect that. In summary, though it's a bit more technical. So I think there are two lines of cases now we see.
Yeah, very true. Still, we need better, let's say, discussion on whether someone can file a court case, file a case to questions on that constitutionality of the amendment in 1981. There's still some debate on this, as Luq explained. Macam we were talking about last time kan, Luq, pasal doctrine basic structure and all kan.
Yeah.
So these are the things lah. Whether that basic structure is applicable or not is still two different line of thought or two different court decision kan.
So they were arguing on that, Prof. Sham. Actually, because the basic structure, right? You cannot oust the jurisdiction of the courts, right?
Yeah.
I think there are two lines. I think there are two lines of cases. I don't think the issue is a settled issue yet.
Yeah, true. I don't think it's a settled issue, but we look at the plain provisions. When we go to the details of what the court says, we have other things. There's something like act on advice or not. Yeah.
Yeah. True.
Two things that being up under. I say that we lay down what's the technical issues and what's our preference. The court may think otherwise, kan? Okay, thank you.
Any other questions? Let me check the last round. I think let me see the chat. I think there is no more question here. I think what can we do to oppose? Wait, is there a question? Oh, from Encik Halim again. What can we do to oppose the spending of the government that are not for
dan
COVID?
not off for COVID-19. Ini kalau nak buat dewan kat sana tu dah buat sebelum darurat. Kalau yang lain tu saya tak pastilah. What can we do? Of course, we can express our views by having discussion like this. You know, what more we can do as citizens, and what more we can do as citizens. But lawyers may do more. I think, lawyers may do more. They can fight in courts. So there's one thing lah. Let's say we are ordinary people. We are citizens. The ordinary citizen. We have NGO. We have special. What we call, if we have special position, something like peguam ke apa, boleh lah buat file tu, kan, to question. So that's what we can do. Not much actually, but then I have to speak up lah. Thank you.
Okay. With that, I think I would like to end the session. I think. Thank you, Prof. Sham. Sorry.
Thank you.
Wait. Where is the thing? Sorry. Okay. So with that, I would like to end the session. I would like to thank the organizer, the alumni, the IIU, for organizing this event. I would like to thank Prof. Sham. What happened to this? Okay. I would like to thank Prof. Sham for giving us a very enlightening, I think, a deep perspective of things in the Constitution. I think some of the questions was a bit technical, but I thought you have given light to some of these issues. We would like to thank you very much for spending your time and giving your thoughts on this issue. And I think that's all I have for today. I would like to end it with wabillahi taufiq wa hidayah. Wassalamualaikum warahmatullahi wabarakatuh.